Lori Carlton was murdered by her ex-husband, whom she had started seeing again after she had a child with someone else. This happened in a small rural town in Florida, Perry, in Taylor County back in 2020. The ex-husband in question is Kenneth B. Burns, 48, who was arrested in May of 2020, a day after his ex-wife, Lori Carlton, was found dead in Burns' home on Fully Cut Off Road. A deputy said he found Carlton lying on the bedroom floor in a pool of blood. He described seeing Carlton's 8-month-old son, Eli, crying, covered in his mother's blood. Prosecutors ultimately obtained a first-degree murder indictment against Burns, who was accused of stabbing Carlton multiple times. Burns, however, claimed that the killing was in self-defense. At his trial, in which he was represented by attorney Nathan Prince,
"You're not going to want to find the defendant not guilty. Not a single person on this panel is going to want to find the defendant not guilty."
Burns took the witness stand, claiming he killed his ex-wife in self-defense. Jurors did not buy what Burns had to sell, and Kenneth Burns was found guilty of first-degree murder. He received a mandatory sentence of life in prison without parole. He then filed an appeal and is now represented by Michael Ufferman, the same lawyer who represents Charles Adelson on his appeal. On May 8, 2024, the First District Court of Appeal for the state of Florida heard oral argument on Burns's appeal. The main argument made by his appellate attorney for reversal was that it was erroneous for the trial court to allow a witness to testify that Lori Carlton's baby Eli was covered in his mother's blood when he was found by the deputy. Let's see what the judges in the appellate panel think about this argument. Here we go.
The next case we'll hear on the docket is Burns v. State. Is the appellant ready to proceed?
Yes, Your Honor. Good afternoon. May it please the court. Michael Ufferman on behalf of the appellant, Mr. Burns. I'd like to reserve 5 minutes of my time for rebuttal. I'm intending to focus my time this afternoon on the first issue raised in the briefs, and I'll address any questions that the court has regarding the remaining 2 issues. The first issue, I think, is a pretty straightforward issue dealing with relevancy. And when is a matter relevant? If there's limited relevancy, when is the issue or the evidence overly prejudicial such that it outweighs any probative value? And then ultimately, if the court agrees that it was error in this case, was the error harmless? Has the state met its burden of proving that it's harmless? The evidence in question in this case concerns a baby being covered in blood. This is a case of self-defense. My client was charged with murder for his girlfriend at the time, who had an 8-month-old baby in the house. There was no eyewitness. My client's testimony was that he came home late. The alleged victim was upset that he came home late. My client said that she attacked him. He defended himself with a knife. Ultimately, she died from several stab wounds from that knife that, again, according to my client's testimony, they were struggling over. After the incident, my client left. The baby was present at the house at the time. The baby could not crawl, could roll. My client said that the baby was on the bed in the bedroom during the incident, and after the incident, he put the baby on the floor and then left. So before trial, defense counsel said, Your Honor, we've worked out most issues, but the one issue we're still haven't been able to agree upon is I don't think the state should be able to introduce any evidence about when law enforcement officials arrived, the baby was next to the mother covered in blood. And then there was some back and forth discussion where the state said, well, we need to be able to at least establish why it was when law enforcement arrived roughly an hour and a half after the incident, why they came inside. They heard a baby crying out loud, and that was their reason for going inside. And defense counsel conceded that, yeah, I think that's relevant. So I'll agree that that should come in. But at the very least, anything about the baby being covered in blood should not come in. And the judge clarified, you're not going to introduce any pictures of the baby in blood. The state said no. And the judge says, okay, I'll allow the deputy to testify, or the sergeant to testify, that when he arrived, the baby was covered in blood. And this occurs on page 333 of the record, or the trial transcripts, I'm sorry. The question from the prosecutor, this is to Sergeant Thigpen, describe what you saw. When we came into the kitchen, it just looked like a normal kitchen, walked into the living room, and as I come around the corner, following the sound of the baby crying, you could see him sitting on the floor covered in blood. And as we walked into the room, there was a female lying there in a pool of blood. Goes on to say, just to add a little more context, question, oh, all right, whenever you see him, or whenever you say him, are you talking about the baby? Answer, the baby, yes, sir. Question, okay, was there anybody else in the house besides the baby and the deceased female? Answer, no. Question, all right, what did you do next? Answer, once I got to the bedroom, Mike, who is Deputy Mike Vickers, comes right in behind me. He said a couple of words, cuss words, like, you want me to say them exactly? Prosecutor, no, that's all right. Sergeant Thigpen, okay, so he picked up the baby, went outside, and called for EMS. So a little more context. We don't know what those cuss words are describing. Is it describing the dead body? Is it describing the baby being covered in blood? I mentioned, or I've explained in my brief, that we know that there was at least one reaction to what was seen by law enforcement officials when they arrived, because one of the jurors' wife was on the EMS crew. And that juror was discussing in chambers about whether or not that juror had any knowledge about this case. And that juror said, did your wife talk to you about the call that she had received? And the prospective juror, who did not serve on this jury, just briefly, she had some issues. That's all. Prosecutor, I'm sorry, if you don't mind asking, she had some issues? Juror, yeah, she just described to me in reference to a baby that was covered in blood that she had to hold. So clearly, before this occurred, before the argument was even made, we know that this is, Taylor County, it's a small county, but there's at least one juror who had a connection to EMS and law enforcement who had responded to the scene and already said, I had some issues because the baby was covered in blood.
Can I ask you, counsel, you mentioned no photographs. You would concede that this didn't become a central feature of the trial, right? So the more probative than prejudicial assessment, that's a abuse of discretion standard,
yes,
right? So how do those cases where there's bloody autopsy photographs and the prosecution's really hammering this extraneous stuff, how does that apply here when we've got apparently just one mention of it and no photos?
So you talked about more probative. I would maybe say that perhaps falls into the last category I was discussing, which is harmless error. Because I still think there has to be the initial discussion for the first two pots that I was talking about. Is it even relevant? And if there's any relevance, does the probative impact outweigh, does the prejudicial impact outweigh that probative value? The judge makes that decision pre-trial. As far as what happened from that point forward, I agree with you, Your Honor. This was not mentioned in closing. So from a harmless error standpoint, that the cases that, and I think the parties below said, and we haven't found any obviously on appeal, there's no case dealing with this exact issue. I didn't look to the cases that actually had photographs. And some of those cases do involve perhaps the issue being mentioned by the prosecutor in closing, and that goes to, is the issue harmless? If I could come back to whether it's harmless, I still want to talk about it's simply not relevant. The baby being covered in blood is not relevant to any issue in this case.
Is that issue preserved? Did defense counsel make a specific argument that it was irrelevant? My
Yes.
understanding is that it was, primarily a 403 argument, which is not an argument that it's irrelevant.
No, well, no, if you look at page, after the prosecutor made the argument as to why there may be some relevance. This is page 298, Mr. Prince. Just briefly, Your Honor, he goes on to say, the state is not bound to accept the defense stipulation. That doesn't mean the defendant acknowledging certain facts. If it was going to be disputed that the killing took place at 2 a.m. versus 4 a.m., if that was disputed, then that evidence would have a higher probative value. I'm telling the court that's not a dispute. And he goes through and mentions each of the things that the prosecutor referenced as to why this could be relevant.
Well, why is it not relevant? What is your argument there precisely?
So let's look at the definition of relevancy. Evidence intending to prove or disprove a material fact. This baby being covered in blood is...
Well, I understand that, but when you're talking about a trial over an issue of self-defense, the fact that there's a baby in the house and the baby is, let's separate the covered in blood aspect for a second. Would you agree that the fact that the deputy saw a baby there would be relevant?
Yes, and I will, not to shortchange you, but
Sure.
the covered in blood is the issue.
Right. Okay.
Sole issue I'm arguing.
Okay.
The
So-
baby being there is relevant in every other way. I acknowledge that. The baby being on the bed is relevant. The baby being placed on the floor, that's relevant. I don't dispute that. Certainly the state can point to, so I'm saying, even just a little bit of relevancy, I'll concede. The baby being in the bed where my client is saying this occurred, of course the state's gonna be able to say that. I'm not sure that's true, or maybe it started in some other room, or do we really
But
believe?
just being covered in blood go to premeditation?
The baby being covered in blood go to
In
premeditation.
other words, isn't the argument or the allegation that he put the baby on the floor by the mother, the deceased woman? Is that part of the state's case?
I don't believe so.
Well, so tell us what occurred in terms of what your client said about the baby, and doesn't it go to the context of how'd the baby get on the floor covered in blood?
I don't know that we know how the baby got covered in blood. I
I
think,
assume by being next to the deceased woman, right?
right. So again, we know the baby couldn't crawl, the baby could roll. My
But doesn't it
client,
go to his state of mind that, again, this is just a question, it's not an accusation. But does it go to the state of mind or of why he didn't try to help the child? I mean, isn't that fair for the jury to know? He's arguing self-defense. She tried to attack me, understand that's his testimony, and the jury certainly could consider that. But can't the state argue, well, then why did you leave the child there?
well,
Covered in blood. I mean,
so again, we don't know that the baby was covered in blood when my client left the baby there. When I've read these facts, and I've never considered it any other way, I believe that my client was concerned about the baby's well-being, which is why he took the baby from the bed and put him on the floor, because falling off the bed would be dangerous to the baby.
right.
So there's an assertion by the state when this is being argued that, he didn't care for the baby. I mean, he fled, and I'm not spending much time on my second issue because I acknowledge the fleeing is consciousness of guilt, or at least the state can argue that. So him fleeing, but when he came back, the first thing he asked, and that came in during the testimony, is the baby okay? But he's not charged with child neglect. He's not charged with anything relating to this baby. The baby is unharmed. So the fact that the baby is covered in blood, again, I don't think is relevant to premeditation. I don't see it. I don't think it's relevant
Well,
to any
the
issue.
argument was he placed the baby on the floor next to the mother, right?
I think it's he placed the baby on the floor. So as far as the state
But
wanting
does that not go to the idea that your state of mind is such that you have no concern for the child whatsoever, other than, okay, yes, I put him on the floor to make sure he didn't fall, but
I guess
that doesn't really go with a kind of self-defense claim, does it? In other words, would a commonsensical view of a self-defense claim be, I'm calling the police, I just had to defend myself against my ex-wife, I've got the baby here, I want to make sure the baby's okay, rather than I just show up at the police station and say, hey, is the baby all right? I'm asking.
It was at his house, but no, you're bleeding into the second issue, and which is why I was, yes, I understand those are concerns that would potentially, the state could point to as being contrary to self-defense or allow, get over potentially a JOA issue. But as far as, again, I guess the way I'd answer the question is this. If the baby being covered in blood was relevant to any of the issues the state was trying to prove, then going back to whether it became a feature of the trial, you would have expected the state at some point to make that argument to the jury. And you see, to properly establish that either premeditation or whatever it might be relevant to, that's why the baby being covered in blood is relevant. The baby being covered in blood wasn't mentioned a single time other than the deputy talking about seeing the baby in blood and then what the other deputy's reaction was to it. So I don't think the prosecutor thought it was relevant to anything, because the prosecutor certainly didn't make that point to the jury throughout the trial. I think the idea was, especially when you've just heard in jury selection that one of the jurors' wives had this reaction to this case, and what the reaction was not her being the alleged victim being covered in blood. It was the baby being covered in blood. So now I really want to get that point in front of the jury, just for whatever impact it might have. And that would be improper.
And
Because,
I know we're well into your rebuttal time, but can I just ask you briefly about your second issue?
of course,
And I'm going to grant him another 3 minutes.
Thank you,
on the
Judge.
other side.
I appreciate that. The excessive self-defense, would you agree that at some point, if there's enough excessive self-defense, it can become premeditation? So if somebody, I've got a bat, some kid comes at me and I hit him one time with the bat. Okay, maybe that's excessive self-defense. He's lying on the ground and I hit him 20 times with the bat. At some point, maybe I'm premeditation, I have premeditation, a time to reflect, a time to stop, and I don't. So then it's conceivably murder if I kill the kid, right?
it can be. I think there'd be, I think from a legal defense standpoint, if that's the type of reaction you're having, perhaps you're now going into the territory of some type of heat of passion that you've lost control in your response. But I also acknowledge that's not going to be an issue for JOA. That's going to be an issue that can be argued to the jury.
Right. So, I mean, intent and the timing, I mean, we've said, the premeditation can be formed in just mere seconds, pull a trigger and that's premeditation conceivably, or that's enough for a jury to find premeditation. So, I mean, isn't it the same thing?
JOA issues are very tough.
Here, basically. Thank you.
I acknowledge that the difficulties with the JOA claim because of the potential animosity between these two that existed from evidence that the state presented pretrial, from the fact that he fled, which the state can utilize as consciousness of guilt, and from the fact of the snitch statements that came in. Of course, my client denies those statements having been made, but nevertheless, that's evidence that came in that the judge had to look at in the light most favorable to the state. So
I appreciate your candor.
okay, thank you. I'll reserve the rest of my time for rebuttal.
My name is Darren Snoopy. I represent the state of Florida in this matter. There's 18 minutes on there. Do we have 18?
I gave you an
No,
additional 3 minutes. You're not required to use it, but you have it in case you
All right,
prefer
thank
to
you very
use it.
much. Thank you very much. I'm going to start with, when you kill somebody, and it happens, and you decide to use a 5 to 7 inch knife blade to do so, and you stab that person, you cut them up to 8 different times, one of those being a slicing of the throat and the others being stab wounds to the head, various parts of the head, the neck, the upper torso, all evidence of a conscious intent to kill, which supports premeditated murder. You probably shouldn't be surprised that there's going to be a lot of blood. So I'm a little bit, as I indicated in the answer brief, surprised at the claim that if the defendant admits to putting the baby on the floor after having killed that baby's mother, with the baby being only 8 months old, and then leaving the baby there, going off to stick his truck in a ditch somewhere and then run off into the woods with the murder weapon. Why would he be surprised that there's going to be blood all over the baby? Who's able to roll over, but not walk, not crawl. So it would offend the intelligence of a group of jurors, in this case, to think that, well, you left the baby behind, and wasn't it just amazing that the baby didn't get a drop of blood on him, excuse me.
What's the state's argument that I mean, certainly the baby is relevant. I think that's conceded, and the position of the baby and, the officers here and the baby coming in. What's the state's argument that the baby found with blood on him is relevant?
Well, first of all, let me flip to the end of that, and then I'll come back to answer it. The argument made below, and the argument this defendant is stuck with on appeal, is that this was as the trial counsel said, a straight 403 analysis. Well, that's important for this court's consideration, because a straight 403 analysis means I've conceded that the evidence is relevant. What I'm arguing is that the relevant evidence is substantially outweighed by the concern of undue danger. So
And-
that's
and-
where they are.
And I think Judge Winokur was getting into that with your opponent. Is there a relevancy objection first before we even get into the more prejudicial than probative analysis? Or are you
Well,
saying there wasn't a relevancy
Well,
objection preserved?
that's not preserved, number one. I want to make sure you understand that. And as we put in the brief, what's relevant about the baby being covered in blood is that the medical examiner's testimony in this case was that the baby's mother died by blood loss. The baby, having been placed next to the mother, supports and corroborates the fact that the mother died as a result of blood loss, and she died within less than, according to the medical examiner's testimony, in less than 15 minutes. So the baby being covered in blood, having been placed next to the mother, verifies, supports, corroborates, whatever words you want to use, the fact that the mother bled out. That's how she died. Because one of the stab wounds cut the carotid artery in half, separate and apart from all the other damage that was done. So it is relevant to prove how the mother died, which was by blood loss. That's number one. But number two, that's not the preserved argument. And 403 says relevant evidence, that's what we're talking about. If we've established that it's relevant, they didn't argue below that it wasn't, because they said, quote, straight 403 analysis, those are the words of the defense counsel, is inadmissible if its probative value is substantially outweighed by the danger of unfair prejudice. So the burden on the defense below and on appeal is to didn't convince the trial court, nor should they be able to convince you that the probative value was substantially outweighed by the danger of unfair prejudice. Once again, go back to what I said at the beginning. He stabbed her. By my count, according to the testimony, 7 times, plus he cut her throat with what was described as a gaping wound. So we shouldn't be surprised if her cause of death is she bled out in less than 15 minutes, which is a short period of time. But given the damage he did to her, perhaps we shouldn't be surprised that anything placed next to the mother, put a blanket there next to her, put a dog next to her that doesn't move, they're all going to be covered in blood because the floor was covered in blood. The mom is covered in blood. That's what happens when you do that kind of damage with a knife, 5 to 7 inches. So they've got to convince you at this level that the probative value was substantially outweighed by unfair prejudice. They can't do that. So we got Deputy Thigpen comes in, testifies to what he testifies. He's following the cry of the baby. The alarm goes off at 4:28, I guess, according to the Safe Touch records. So they respond. They're there in about 10 minutes. They're hearing the cry of the baby. They make their way into the house. As I recall, I think the door was open. Find the baby, pick the baby up and next to the mom. And like I say, why would we be surprised that the baby would be covered in blood? But once again, he's a murderer. We shouldn't be surprised, nor should we give them some sort of insulation that if you cut up the mom like he did, you don't get to just stick your head in the sand and say, you know what? We don't even like the facts of this case, but we don't want the fact that, you know, we left the baby behind. He didn't get charged with that. It's not a criminal offense that he got charged with. But the fact is he left the baby behind. He left a non-testifying witness behind, and the witness was covered in blood. So how is that not relevant? And you know what? As a murderer, you get stuck with what you do. He's stuck with it. Nothing he can do about it. The law supports that. And there's no case that says he doesn't get the benefit of it. I think the one case that was cited by the defense in this instance on appeal relates to someone who was killed, as I recall, by being shot in the back. But what was introduced into evidence at trial was, I think, an autopsy photo of perhaps the head. And that's a case, by the way, from 1990. So we're going back, what, 30 plus years? That says, yeah, well, under those circumstances, you could have handled it a little bit different. But once again, we shouldn't be giving props and giving benefit and credit to someone who sliced and diced a mom and left behind her 8-month-old baby in the pool of blood. So in talking about the second claim, let me remind the court that there was testimony at trial as it relates to first-degree murder, that the aggravating bitch got what she deserved. And he said that more than one time to the person who came into court and testified, who was serving a prison sentence at the time. The aggravating bitch got what she deserved. Could we have any better evidence that he had a conscious intent to kill than the aggravating bitch got what she deserved? There were no defensive wounds on her. All the wounds were mid-chest and up, according to the medical examiner. And importantly, remember the context of this case and the arguments that were made below, which was the defense counsel tells the jury this was an immoral killing. It shouldn't have happened. The stand your ground law is a bad law. I'm a defense lawyer. I use it all the time. It's a horrible law. This was an immoral killing that he's got to live with. Well, yeah, he's got to live with it, but he ought to be living with it for the rest of his life in prison based upon what he did to a defenseless woman. And according to testimony at trial, when he returns 36 hours after he's done the deed, he's asked, do you have any injuries? He says no. So when you add all that up and you put it together and you give a package to the jury, what have you given them? You've given them somebody who was mad, who was frustrated, who didn't deal well with the fact that he got to his house late and she's waiting for him because he'd been out at a bonfire. Probably reasonable inferences, they get into some sort of argument, and you know what? He loses it, gets a hold of the knife, takes the 5 to 7 inch blade, plunges it into her at least 7 times and at least another time, then slices her throat wide open. Has the presence of mind, however, under those circumstances, to take the 8-month-old baby, it's not his, by the way, place it on the floor next to his mom, and then gets out of Dodge, which is consciousness of guilt. He exactly knew what he was doing. He can stick his head in sand now. He can testify all he wants, which is what he did. I don't know what I did. I don't remember the details of that. Well, it's funny. You know what? You remember the details beforehand, and you remember the details afterwards. It's a remarkable coincidence, don't you think, that you don't remember the actual part where you sliced and diced her. Wow. But the jury didn't buy it. The argument below was he was justified. Defense counsel used this argument, justified in killing her. Acknowledging it, admitting to it. But he was legally allowed to do it according to defense counsel. Apparently, the argument made on appeal. Well, the jury got to consider that. They're the finders of fact. Took them less than 3 hours to say, that was actually after a few questions that they asked as well. None of which, by the way, none of the questions, there was more than one question from the jury, none of the questions related to, you know, let's talk about that baby covered in blood. Nothing. So there's the isolated reference at the very beginning of the trial. We got a trial transcript that's more than 750 pages, as I recall. There's an isolated reference to it. And somehow or another, that relevant evidence is supposed to substantially outweigh is outweighed by the danger of unfair prejudice. Doesn't fit very well. But in any event, the jury saw it for what it was in less than 3 hours and convicted him as charged of first-degree murder. I think I've covered everything that I can cover with you all today. We're asking the court to affirm the conviction, affirm the judgment and sentence we acknowledge in our brief with respect to claim 3. There are some issues with the costs that were imposed. We'll rely upon the brief for that, but there's no merit.
So actually, I have a question for you about the cost issue.
Okay, yes.
And of course, appellant can respond. There's a concession that because there was no statutory authority given for some of the costs, that they should not be imposed. But my understanding of the rule is that the statute needs to be referred to, or an explanation in the record as to what those additional costs represent. So if there's a explanation in the record as to what the additional costs represent, is that sufficient to affirm the sentencing order or the cost order?
I don't recall the specifics. Knowing how those things kind of work as a practical matter, it would seem that there should be some reference to that at the time of sentencing as opposed to something related afterwards.
But if it's at the time of sentencing, an explanation in the record as to what the costs are.
Then if there is an explanation, then I stand corrected with what I wrote. Okay, I will acknowledge that. Okay, thank you.
Thank you.
Hey, please, court. I don't want to spend much time on that question, but I'm looking at page 644 of the record, and I don't see an explanation. So if you, Your Honor, seem to be referencing something that might be in the record, that would be the explanation. And if there's an explanation that puts me as appellate counsel on notice for the basis for this charge, then that would be an issue.
When the court announced the $201 cost, had the transcript page. I don't think I have it with me right now. But, was associated with the statute covering batteries and other crimes. In other words, there was certainly an indication, not certainly, but there appeared to be an indication in the transcript that was the purpose of the $201 fine, which just so happens to be exactly what the mandatory cost of Section 9(8), I believe. Sorry if I got that wrong.
$151. I'll quote it, Your Honor. I'm on page 644.
No, not the $151.
I'm going to quote it, Your Honor.
Okay.
Quote, the $151 and 101 surcharges related to batteries and other violent crimes. I wouldn't know what that means. And I'm the one that raised this motion. So the whole idea is to put reasonably intelligent people on notice as to you would know that 151 and 101 surcharges related to batteries and other violent crimes, and the clerk said 201, excuse me, that makes it clear to anyone reading that what the statutory basis is for the imposition of that cost. I'm not aware of that, and that's the whole point of me filing my 3.800B motion. If the court would have taken the time to look at the motion and rule on it within the 60 days, maybe there would have been an issue there, but that didn't happen in this case. But this court's case law, the cases around the state say that you have to provide some type of statutory reference in order to allow the appellant and appellant's counsel to understand what the basis for that is. And I simply don't know what that is. I haven't memorized every one of the cost statutes, and I'm pretty familiar with them, probably more familiar with them than anyone in the entire state, because I look at these issues in every one of my cases. I wouldn't know what that means. So I don't think that supports that. Let me get back to this whole idea of this objection and whether it's preserved. I'm not sure it matters. I may be splitting hairs, but the case law talks about any minimal relevance is outweighed by the prejudicial impact. So yes, defense counsel below said it's 403. But we know that magic words aren't required to preserve issues for appeal. And again, it may not matter because clearly he's saying the same thing. Any minimal, that's actually used in his quotes, any minimal relevance is outweighed by the prejudicial impact. But when the judge specifically says, and this is 293, it's your position there's no probative value, he responds by then saying, no, essentially, no, there's no dispute regarding those things. So I submit to you, no probative value is the equivalent of not relevant, but defense counsel is then backing that up by saying in any minimal relevance is outweighed by the prejudicial impact. And then one last thing, Mr. Shippey indicated that, if there was some argument that this baby didn't get a single drop of blood on it, of course, if defense counsel would have made that type of argument, then the state would have been allowed to reopen the case to point out if there'd been a pretrial ruling that in fact this baby did have blood on it. So that's not what was being argued by defense counsel in this case. So for that reason, I'd ask this court to reverse on claim 1. Thank you.
Thank you, Mr. Oakman. Thank you both for your arguments. The court is at recess.
All rise.
A decision in the case can take weeks or months. What do you think the court will do? We will monitor the case and will let you know what the court decides. Thanks for watching Mentor Lawyer and Ladybug.